What is a will, and what do words like testator and executor mean? A will is a formal written document, a set of instructions that you'll leave to the court on how to distribute your property. In that, you can also name an executor. The executor is a person who's going to be in control of gathering all your assets, providing an inventory to the court, and saying these are all the debts they have, these are all the assets they have. If an administration is needed, meaning that they need to maybe keep the succession open to pay debts or wait to receive some money, that executor is the person who's going to pay the debts. They're going to receive that money. And then after they've done an accounting and they've paid all the debts and they've collected all the property and there's no longer a need to keep the succession open, they're going to transfer the property to who was named in the will. Okay, and a will is made by a testator. So anytime you hear someone referring to a testator, that would mean that their succession is testate, meaning they died with a will. So also in a will, you can name a guardian. A guardian is the person who's going to care for your children. If you have minor children, in your will, you can name an independent executor. Should you need an administration like we talked about beforehand, where the person has to either maybe pay off debts or they have to sell things or whatever they need to do to accomplish the goals, if they're independent, they don't have to get court oversight at every step of that process. So if you could imagine everything you need to do, you need to go into court and file paperwork to get approval of the judge to sell an asset, to sell a piece of real estate, to sell a car, to sell anything of value. You also have to advertise the sale of real estate in a paper in a regular administration. If the person is independent, they have an independent administration, then they have no need to do that. So there's two types of wills, a notarial will and an allographic will. A notarial will is a will done in front of a notary and two witnesses, and it's signed and dated on every page, and it also contains an attestation clause, which basically makes that will self-proving, and there's no need to prove at a later date that that was in fact your will. An allographic will, on the other hand, is written completely in the testator's handwriting. It's signed and dated on every page, and it's clear that they make an intention to give their property to someone. The downside to this will is at a later date, it needs to be proven by two credible witnesses that this was in fact the testator's handwriting. And the problem with that is sometimes there's not someone around who can actually give credible testimony to whether that was in fact the handwriting, especially when the person who may be giving the testimony is also the person that's receiving. So it's hard to classify them as a credible witness if this will would give them everything. So that's the downside to an allographic will, but an allographic will is something that you can do for free. It's something that you can do in a pinch. But I would probably advise to do a notarial will and have it passed in front of a notary and two witnesses and have that attestation clause.